Welcome back. My name is Jessie Hill, and I'm an assistant professor here at the law school. And I am pleased to introduce our next panel entitled The Copyright Treaties and Digital Rights Management. Our first speaker will be Gwen Hinze. Ms. Hinze is an attorney specializing in international intellectual property issues and the International Affairs Director of the Electronic Frontier Foundation. As head of the EFF's international program, she focuses on educating policymakers at WIPO, international standards bodies, and elsewhere about the need for balanced intellectual property regimes that protect creators, preserve access to knowledge, foster technological innovation, and empower digital consumers. She is one of the co-authors of the EFF's report, Unintended Consequences, 7 years under the Digital Millennium Copyright Act, and has testified before the U.S. Copyright Office regarding the DMCA, as well as commented on various countries' implementations of the TPM obligations in the WIPO Copyright Treaty. So I'll turn it over to her now.
Thank you for the opportunity to talk with you this afternoon. The WIPO Copyright Treaty and the Performances and Phonograms Treaty heralded the start of the brave new world of legally enforced technological protection measures, technologies that can be used to restrict access to and use of copyrighted works for the purposes of avoiding copyright infringement and enforcing contractual restrictions. Although rights holders may have sought legal protection for their technological measures for the legitimate purpose of protecting their copyrighted works, as the last 7 years of experience with the US implementation of those obligations, the Digital Millennium Copyright Act has made clear, overbroad legal protection for technological protection measures can have adverse consequences on a range of important public policies that extend beyond the normal sphere of copyright regulation. In the United States, the DMCA has redrawn the traditional balance of interests in US copyright law, chilled freedom of expression, and threatened technological innovation. Based on the experience in the United States and in other countries that have implemented the WIPO Treaty's obligations for TPMs, it's now clear that policy choices about the scope and structure of legal protection for technological measures play a very significant role in national public policy priorities and global information policy. In fact, the impact of DRM laws and how to structure them have been an important part of the discussion of member states at the World Intellectual Property Organization in the discussions on a WIPO development agenda, precisely because overbroad protection for intellectual property rights holders, TPMs, can restrict access to knowledge. So with that in mind, as we approach the 10th anniversary of these international obligations, I think it's appropriate that we consider two questions. First of all, what lessons can be learned from those countries that have implemented the WCT and WPPT's obligations? And secondly, the factual question that never seems to get asked but perhaps is less legally interesting, and that's whether legal protection for technological protection measures has been successful for the stated purposes. Has it been successful at preventing widespread digital copyright infringement? And since I'm not sure I'm going to get to deliver my punchline, let me just say on that point, I think the answer is no. That won't be a surprise to many of you, but let me just say that. So in my presentation today, I'm going to analyse some of the public policy implications of the scope of legal protection for TPMs based on the US experience with the Digital Millennium Copyright Act. I'm going to apologise up front for the use of the acronyms, but if I have to spell them out each time, we will be here all day. So TPMs is what I'm going to say, and DMCA is what I'm going to say. I've chosen to focus on the US experience for a couple of reasons. First, because there's a wealth of case law here. We've now got a fairly well-developed sense about some of the application of some of the principles there. And secondly, because of the role of the United States free trade policy in this area. The last 10 free trade agreements, bilateral free trade or multilateral free trade agreements that the United States has entered into with its trading partners since 2002, with the sole exception of the Chile Free Trade Agreement, they've all contained obligations for our trading partners to adopt legal protection for technological measures that is modelled very precisely on the scope and structure of the legal protection in the Digital Millennium Copyright Act. In some cases, such as the situation in Australia, other trading partners have already had laws, and those laws have had to be rewritten to match those of the US model. So my goal in doing all of this is to come up with some recommendations for what might be considered, well, I'm not going to use the word best practices, since I don't think that it's possible to have best practices in this area, but what I would say damage mitigation principles. How can we implement these obligations, looking at the scope and the structure of legal protection in a way that does the least harm to the other non-copyright interests that have been implicated by the overbroad implementation in other countries? To put all this in context, let's go back and remind ourselves about what the full range of policy options are for countries that are considering implementing the obligations in Article 11 of the WCT and, in similar terms, Article 18 of the WPPT. Well, the wording is familiar to everyone in the room, I'm sure. Adequate legal protection and effective legal remedies against circumvention of effective technological measures. What does that mean? Well, that's been a matter of ongoing debate for the last 10 years, so I'm not sure that we can come up with an answer that will satisfy everyone. But what I want to do today is just to distinguish again, so that we're all clear that there are different ways of implementing these obligations. And in particular, I think there's three different dimensions to the scope of legal protection that frequently get overlooked or that consideration is not given to. So I want to just carefully outline how I see that grid of options. First, countries can choose to ban acts of circumvention, so a direct violation of these obligations, or they can choose to take what might be called an indirect or secondary liability process. They can have a ban on tools or devices, what is called preparatory acts in much of the international literature in this area. Or, of course, they can do both. Article 11 is silent on this point. It doesn't make any particular reference to tools or acts, and in fact, people who are familiar with the history will know that the draft basic proposal that was put forward for the WCT actually had quite a specific tools ban in it, part of the proposal put forward by the United States. That was not acceptable to member states, and as a result, we have the more broad open-ended language that we currently have in Article 11. I also just want to point out that there are different policy implications for each of those. Obviously, an act ban applies to individuals who are doing acts often inside the home, so it raises enforcement issues about how you police that. A tools ban, on the other hand, while it usually will apply to commercial vendors, people who we might want to have the burden placed upon, also harms consumers because it chokes off the supply of tools that they might otherwise need in order to circumvent for non-infringing purposes. The second dimension here relates to the nature of TPMs, and that's the question about whether Article 11 requires protection of copy controls, so controls that merely address use restrictions, or whether it actually includes a requirement to implement access controls, blocking access to a protected work. The third dimension is the scope of that. Does a TPM only get protection if it's limited to the scope or contours of national copyright law? Or does a law grant absolute protection even if the TPM restricts acts that wouldn't amount to copyright infringement or otherwise go beyond the scope of national copyright law? This is particularly relevant because the question is that many people have raised since 1996 is whether the WCT creates a new right to control access. Different countries have implemented that in different ways, and it's been a largely unresolved matter in the legal commentators. They're pretty evenly divided on this point, and it's the issue that is front and centre in the free trade agreement area, where the US is requiring all its trading partners to adopt effectively a right to control access based on the equivalent provision in the US legislation. So where are we after 10 years? Well, there's a number of different approaches to TPM laws that have been tried in different countries. As I said, I'm going to focus on the DMCA, but I also just want to mention, I guess, what I see as the three main approaches are. The DMCA, because of free trade agreement obligations in particular, it's becoming an emerging global norm. The EU Information Society Directive, now 25 member states have implemented that, so there's a body of experience there to look at. And the third approach, which is not really on my slides, but is obviously sort of another major approach to watch, is the WIPO model copyright law. As Ruth mentioned this morning, WIPO has a technical assistance program, and part of its agenda and part of its activity in the last few years has been helping countries to implement these obligations in accordance with the TPM provision in that model copyright law. So I would say that's the third main approach. I'm going to spend a little time with some detail about the US framework. The reason I want to do this is because there are particular features of the US framework that have led to the range of unintended consequences that we've seen. The use of TPMs to do things other than stopping piracy was in some cases not foreseen, in some cases foreseen, but in each case I think some of the overbreadth of the DMCA and some of the stories we've reported in the unintended consequences report that are in your materials can be explained by the scope of protection that the DMCA has. So please bear with me for the exciting legal framework part of the discussion. The DMCA takes a maximalist position on almost all three of the dimensions I mentioned before, the three dimensions of scope. It bans both the active circumvention of a technological measure that controls access to a work, not copy control, just access, and it also has a ban on the manufacture and distribution of tools that can circumvent both access controls and copy controls. There are 7 exceptions to that ban for a range of public policy purposes, things such as reverse engineering and computer security testing. And they are exceptions to the Act ban. On the tools side, there are a limited subset of exceptions for use of tools for those 7 acts. So it breaks down something like this. There are, for access control tools, there are 5 exceptions. For copy control tools, only 2 of the 7 areas of 2 of the 7 exceptions have a corresponding copy control tools exemption. And finally, the DMCA has a rulemaking process that takes place every 3 years, whereby the Librarian of Congress, on recommendation from the Copyright Office, can grant a 3-year exception or exemption to the Act ban, but not to the tools. I'll talk more about that in a moment. I should also point out that every single one of the features I have just mentioned is in the Free Trade Agreement language that the intellectual property chapter of each of the last free trade agreements, with the exception of Chile, have basically mirrored that framework, including the triennial, or in some years a four-yearly rulemaking process. But that framework is what our trading partners are now looking at implementing. The DMCA doesn't define effective technological measure, the term that's actually in the WIPO language. Instead, it defines 2 other terms: to circumvent a technological measure, and it also defines to effectively control access to a work. The key point, and the reason I have this information up on the slide, is to draw your attention to the fact that it defines those terms by reference to authority of a copyright owner. And that's been an important part of the litigation to date, because it has been seen as a fairly open-ended question about whether that goes beyond this, whether the authority of a copyright owner covers works that are broader than the things given that a copyright owner is granted under the Section 106 rights of the Copyright Act. I also want to briefly discuss the nature of the tools ban. It's important. Essentially, I think of it as a disqualifying text. You can use a tool unless it meets any one of these 3 factors. If it meets one of these 3 factors, then it's considered a banned tool, and even if it's got other useful purposes or could be used to make substantial non-infringing uses, blah, 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 it's out. So it works as a disqualifying tool, disqualifying structure. If your tool can meet any of these 3 factors here, it is banned for the purposes of circumventing either an access control or a copy control, and so those tools will disappear from the marketplace. And finally, or close to finally, I wanted to look at some of the recent case law to give you a sense about things that are not protected under the DMCA. So we've now learnt that where it's possible to make use of a work through an alternative access route, then the work won't be considered to be there won't be considered to be an effective access control on the work. The language that most people have referred to here is the Sixth Circuit appeal in the Lexmark case, the printer control cartridge case, talked about where it doesn't matter if your back door is locked, if your front door is open. And the idea there is that if the particular protected work can still be accessed, then it doesn't matter if you say that there's a technological measure there. If there's an alternative way of accessing it, you don't get legal protection. The second point I've got here is, I think, the key point about the recent case law that really needs to be highlighted here, and that's this. The DMCA only extends legal protection to a TPM if circumvention of the TPM either infringes or facilitates infringing a right protected by the Copyright Act. So that's a long way of saying you need to have a nexus between the TPM and facilitating or infringing copyright. Those two cases that are listed there, the two Federal Circuit cases, dealt with tools. So where we get to overall is basically this. The scope looks something like this. We have an absolute ban on accessing a TPM, and we have a ban on use of importation, manufacture and distribution of tools that has to have a nexus to the act of infringement. That's not the same thing as following the contours of copyright. There's still opportunities for access controls and for the tools that might be used to circumvent those access controls being broader than the scope of copyright law, and that's the relevant point. In the last 7 years, the DMCA, as I mentioned, has proven to be overbroad. It's overridden copyright law exceptions, it's chilled scientific research and publication, and it's been used in a range of ways that have impacted public policies outside the copyright sphere. Today, I want to only touch on 3 of these for the purposes of trying to highlight some of the particular unintended consequences and their relationship to the legal structure I've just outlined. But in your materials, you have our report, Unintended Consequences, 7 years under the DMCA, that actually lists all the cases that have arisen since these provisions went into effect. So the first major result and unintended consequence of the DMCA has been that copyright law has effectively been supplanted. Effectively, the DMCA has created a new access right with protection above and beyond copyright. And what we've seen is that the balanced set of rights that previously existed in the US Copyright Act have largely been replaced by this broad anti-circumvention law. To put it in simple terms, copyright law has been ousted by technological protection measure laws. We're talking about whether you violated or didn't violate a TPM measure. We're no longer having those nice, interesting, nuanced discussions about whether what you've done serves copyright policy. That is now largely not part of the discussion. So effectively what that's done in the US context has overridden fair use and the other statutory exceptions in the US copyright law for technologically protected works. It's not that Congress wasn't aware that this might happen. In fact, it was quite aware. What we saw in the legislation was an attempt, a legislative attempt to try to signal what the impact of these laws would be. There's a provision in the DMCA in 1201C1 that seems to be intended to clarify that consumers could make fair use of lawfully acquired digital works to which they had lawful access. But what you can't do is have a right to proactively circumvent in order to make fair use. So if you've already got access because you've purchased your song from iTunes, you potentially have a right to make a downstream fair use of it. All good and well, that's all clear. Except that, in practice, that has been meaningless because the DMCA has banned the tools that most consumers would need to make that fair use. Unless you happen to be a computer scientist or tech savvy enough to create your own tools, the tools that you will need to make the downstream lawful fair use don't exist in the marketplace because of the tools ban. And a series of cases concerning the DVD decryption software, DCSS, have made it clear that if the software falls into one of those 3 factors I showed you, then it's out, it's banned, and it gets taken off the marketplace, even if it's capable of allowing consumers to make lawful fair use or other lawful statutory exceptions. Thus the dilemma. Well, as I mentioned before, Congress also tried to deal with this by including a rulemaking process, a 3-yearly rulemaking, where it was intended to provide a fail-safe mechanism to protect consumers' non-infringing uses. And the idea was that the Librarian of Congress, on the recommendation of the Copyright Office, would consider exemption requests and grant exemption to the ban on circumventing a technological protection measure. That has not been effective at protecting fair use for consumers, largely for two reasons. First, the terms of the process have been extremely limited by the actual structure set out in the statute. The Copyright Office and the Librarian of Congress can only exempt circumvention acts. They can't actually grant an exemption for the tools that you would need. So we have the same problem that we have for the general principle here, that unless you are a computer scientist or tech-savvy enough to create your own tools, even if you're lucky enough to convince the Copyright Office and the Librarian of Congress to grant your exemption, you can't actually use the exemption unless you can create your own tools. And the majority of consumers aren't in that situation. The second reason why that process has just been unuseful is largely because of procedural burdens. It's an extremely technical process. EFF participated in 2003 and 2000. We put forward a set of consumer exemption requests dealing with such strange and wonderful things as the ability to skip through non-skippable commercials on a DVD, non-infringing use, and the ability to play non-Region 1 DVDs lawfully acquired in other countries where the work wasn't available in the United States. We wanted people to be able to play them on their US players. Everyone agreed, non-infringing use, no exemption granted. There's a lot of details about how exemptions have to be framed. They have to be framed as a class of works. There's a number of reasons why that process is very limited in what it can actually do. The point is, we now are in a situation where there's a fairly limited scope of things and a limited scope of people who can actually make use of those exemption requests that have been granted. There have been 5 to date. And the great hope that that process would actually preserve consumer fair use of technologically protected works is now, we now realise that that's not going to be the case. In the interest of time, I'm going to skip the other point that's on that slide there, but I just want to point out that this applies to all exceptions and limitations. It's not just about fair use. So in terms of public domain works that aren't covered by copyright because, for instance, they're no longer under the term of copyright, there is no way to access a public domain work. There's no way to lawfully access a public domain work, for instance, a public domain motion picture that is on a DVD with CSS encryption, which is stored with other copyrighted works. That was, again, one of the exemptions requested by EFF in 2003 that was not granted. One set of unintended consequences. Second set of unintended consequences. Many people are familiar with these cases. There's a series of cases that were where really the DMCA has facilitated anti-competitive misuse. US copyright owners have used the TPMs backed by the DMCA to obtain what is effectively a new monopoly over non-copyrightable products that interoperate with their products. So this has had anti-competitive impacts for consumers. It's also prevented technological innovation and the creation of new interoperable technologies. A number of cases will be familiar to people here. The one that most people probably know about is Lexmark's effort to ban an aftermarket in refillable printer cartridges. There was a case involving a garage door remote control. A company sought to use the DMCA to ban its competitors' universal remote control from the marketplace on the basis of the DMCA claim. Most recently, cell phone unlocking, attempt to use the DMCA to stop people from unlocking their cell phones to change providers and keep their number. And an independent computer service maintenance contractor who ran afoul of a proprietary data storage company's desire to have all of its maintenance work done by its technicians. These cases have all had the effect of locking consumers into purchasing higher monopoly-priced goods, but they all turn on particular features of the DMCA's legal structure. There are a couple of features that are obvious here. The one I want to draw your attention to is the definition of circumvention by reference to authority of the copyright owner. Again, a number of these cases made that argument as the basis for asserting this claim. while 3 of these cases were ultimately resolved in favour of the aftermarket party, so what I would call a good outcome, I just want to note here that each of these cases turned on really particular facts. They turned on particular facts about how the technology worked, what the technological protection measure was, and about particular facts about US law. So particular facts about whether a temporary reproduction is a violation of US law, and also particular facts about the way that the legal process is structured in the United States, so statutory exemptions for reproduction of computer programs. My point is, there's nothing to stop these cases from happening again. A clever rights holder could effectively modify their processes to come within the scope of protection here. I'm going to beg your indulgence to give you just one more example of the unintended consequences, and then give you my recommendations for things that you might be able to do to change the way that this works. One of the largely intended consequences of the DMCA was control of the nature and pace of technological innovation. Rights holders have used overbroad legal protection with the DMCA, together with technological protection measures on DVDs and licensing terms, to control the feature set on DVD players. That's covered both region coding, so the fact that we have region coding is largely a combination of those 3 things, but it's also the reason we don't have DVD jukeboxes and why we don't have an iPod for our personal DVD collection. Now, I want to give just a couple of examples here and beg the indulgence of the timekeeper to give you my suggestions for how we might be able to mitigate some of these unintended consequences. I think the first and most important is to limit the legal protection for technological measures to the to the contours of national copyright law. One of the things that is currently up for grabs in the debate in Australia in implementing the Australian Free Trade Agreement and how these provisions how the new provisions in Australian copyright law will work is essentially that question. Do we have to have a legal protection regime that covers access controls, or can we limit legal protection to the contours of national copyright law, what was originally intended to be the point of these provisions? The second recommendation I want to make is for a low barrier administrative process for identifying potential anti-competitive misuse and reduced penalties for good faith circumvention, where people do engage in circumvention with a belief that their downstream act is non-infringing use. And finally, I want to mention the benefit of having a meaningful regular review and exemption granting process that covers both acts and tools, and that has burden of proof requirements that allow consumers to participate in this process meaningfully. Because without that, I fear we've lost not just the benefits of fair use in the United States law, but all the benefits of statutory exceptions that we rely upon and that have made the copyright law as successful as it has been in balancing the interests of a wide and diverse group of people. Thank you very much.
Thank you. Our next speaker is Joseph Liu, Associate Professor at Boston College Law School. Professor Liu writes and teaches in the areas of copyright, trademark, and internet law, with a particular focus on how digital technology is changing the way consumers interact with copyrighted works. He joined the Boston College Law School faculty in 2001 after teaching at UC Hastings College of Law since 1999. He's a graduate of Yale College and Columbia Law School, where he was editor-in-chief of the Columbia Law Review, and he received an LLM from Harvard University.
Great. Well, thanks very much to Case and the organizers, and especially Jackie, for inviting me to participate in this panel. It seems amazing to me that 10 years have already passed since the WIPO treaties were adopted, and I like to think of myself as relatively new to this area. But once you start getting invited to retrospectives where you actually remember the enactment of the thing being reflected upon, I guess that sort of destroys that illusion for me. But I do think it is a good time for an assessment for where we are now. Now, as sort of, I think, the least international person on this panel, I'm going to be confining my comments mostly to the U.S. experience with the WIPO treaties, and so apologies in advance for folks who are already very familiar with this. And then spend some time at the end, I think, commenting on Gwen's excellent remarks on this point. So we have the treaties adopted in 1996, implementing legislation in the U.S. in the form of the DMCA passed in 1998, and then the anti-circumvention provisions going into effect really in 2000. So although it's been 10 years since the treaties, they've really been effective here in the U.S. for about 6 years or so. Nevertheless, I think that is enough time to really see what effect that the law has had. There have been numerous lawsuits brought under the DMCA, and so there is enough material to begin, I think, at least an initial assessment about the effects. There were a lot of predictions about the effects of the DMCA at the time it was adopted. Proponents believe that it would help them stem the tide of digital copyright infringements. Detractors predicted harms to fair use and also innovation. And so the question I guess I'm interested in asking is, well, how have these predictions fared, right? What can we say about the accuracy of these predictions at this point in time? Now, I don't have any empirical data on this, and so my reactions are largely based on anecdotal evidence along with some of the reported opinions. And I do acknowledge that how you look at this depends very much on where you stand or sit. But you know, at least some thoughts about an initial assessment. So I actually want to start maybe counterintuitively with really the benefits of the DMCA. I know that they don't get a lot of consideration, and some might argue that there are none, but sort of thinking about the DMCA in its most favorable light and really geared towards the intended benefits of the DMCA, to what extent have these benefits come true 10 years later or 6 years later, as the case may be? What are these benefits? Well, the strong version of the benefits would be this idea that the DMCA, combined with digital rights management, would really give copyright owners extensive control over uses and copying of their works. And ideally, in its strongest form, the idea would be to lock up copyright works perfectly. Right, to make them sort of invulnerable to copying, and also enable copyright owners to really charge for specific uses of the works, to engage in new business models, et cetera. There's also a slightly weaker version of the benefits. Maybe it wouldn't do that, but at the very least it would make it more difficult for people to infringe. Right? Some people would still be able to circumvent, but it would be hard to get access to the technology, and so it prevents at least the lazy kind of infringer. Right? It would be enough sort of a speed bump to keep people from engaging. So the question is, how successful has it been? Well, I think it's been a pretty limited success. I think the one thing that you can, at least I think, the DMCA can confidently be said to have done is really keep from the broader market commercial DVD copying devices and software. When I think of concretely, right, looking out on the world, how might the world have been different? I think absent the DMCA, we probably would have a lot more broadly available software and devices to enable people to make private copies of their DVDs. DVD backup devices and software, insulated largely by the Sony doctrine. And so I do think that the DMCA has had the effect of doing this, and we have opinions like the 321 Studios case, the Corley case, right, which essentially reinforce that view, right, that say that these technologies are impermissible. And so the net effect is to prevent casual sharing of copies of DVDs among friends. And so maybe a similar role with respect to music protected by DRM, although there's much more music that's not protected, so it's had less of an effect. So that's sort of the one success I would sort of point to as a really concrete result of the DMCA. But that success, I think, is limited in a number of ways for at least two reasons. First, the technology is still available to those who are really determined, and so you can get access to the technologies, copies of software and all the rest over the internet. And so if you're really determined, the technology is out there. And second, and perhaps more fundamentally, digital copies of movies are still available on the internet. Right? You can download them through file sharing networks, BitTorrent, and things like that. There is no such thing as a perfect DRM system. Unprotected copies still leak out. And in any event, people would be able to redigitize the analog signals anyway. And so, to some extent, if that was the goal of the DMCA, then certainly that goal has not been satisfied. So far, ultimately, I think reading this most favorably, you could say that it's been successful in keeping casual consumers from sharing DVDs, but not really successful in some of the more aggressive and broader claims about what it might do. Now, that's not insignificant, right? This might lead to a lot of extra sales for the movie industry. As a cultural matter, maybe it prevents the widespread practice of sharing DVDs, which might kind of reinforce, at least in the movie industry's view, kind of an illegal and improper practice in the same way that music sharing is kind of accepted. But the more aggressive claims of the benefits, I think, have not been realized. Again, that's sort of where we are now. It might be in the future things will change. Well, what about the costs then, right? And so to some extent, this overlaps with Gwen's presentation, and I agree with much of it, and so I won't spend too much time. There are three main predictions, I think, three categories of concerns about the DMCA. First, a concern that it would narrow the effective scope of fair use. Second, that it would harm or slow technological innovation. And third, there might be some collateral impact on speech, research, and things like that. And so addressing these one at a time. First, the impact on fair use. Well, as Gwen's noted, right, the DMCA does not have a broad fair use exemption. Instead, it replaces it with other mechanisms like these specific exemptions and the Copyright Office's triennial rulemaking. To some extent, it's kind of hard to quantify the impact of fair use because these tend to be smaller scale uses, usually no lawsuits, they go unreported, whether they happen or not. It's certainly easy to come up with hypothetical situations where the DMCA would stand in the way. And so the classic example is a film studies professor who wants to use a clip of a DVD, would be entitled to under fair use, but can't do so under the DMCA. And there have been some anecdotal examples of problems there. And so my belief is that it probably has had an impact, but I think it is hard to kind of assess. The impact on innovation might be a little bit easier to assess because I think there we do have more cases and more examples of use of the DMCA in this way. New technologies and devices that interact with DRM-protected works are affected by the DMCA. Right? So if I want to create a device that plays or modifies protected content, attempts to do that, to access the works, will lead to DMCA liability or the risk of it. Sales of technologies may well violate the tools provision. And so there's a concern that this may prevent the creation of new and interoperable technologies, right? Technologies that really add features, but that are really prevented. And so there are some cases of this, threats involving the desire to make certain music formats playable on the iPod, right? Raise this issue. There was the case involving Blizzard Technologies and their game software and an attempt by folks to create a service through which people could play their games online, not having to use Blizzard's service. Again, these are kind of interoperability / innovation cases that raise DMCA issues and might be problematic. One interesting question is whether this is actually a problem or actually a sign of success, right? One could argue that this is actually not a bug, it's actually a feature of the DMCA, and maybe the folks who have copyrights would say this is actually another sign of its success because it actually prevents this sort of thing. But at least historically, as a copyright matter, interoperability was seen as something that was desirable, right? That really wasn't something that we gave to copyright owners. And so I tend to put it on the negative side of the balance. And then finally, actually, related to this last point, I think of even more concern, really the misuse of the DMCA outside its intended area to prevent competition in compatible hardware. And Gwen's already talked about those cases, the garage door opener case, the toner cartridge case, all the rest. I think, in my view, pretty clear examples of the DMCA being extended beyond what Congress intended. And the Court's recognizing that, right? They've since scaled back on it, and I think that has had the effect of greatly reducing some of the danger in that area. And so that's, I think, good news. And then finally, some concerns about the collateral effect of the DMCA on other things like encryption research and the reporting of security flaws and all the rest. And I think, in particular, Gwen's sort of summary of the unintended consequences does a very nice job of sort of highlighting exactly how the DMCA has that effect. Okay, so in sum, I would say that there are many examples of these concerns about the DMCA and the negative impact on the DMCA playing out. I think there is a good deal of evidence about the negative impact here. So overall, I would say the record is quite mixed, right? That there are some minimal benefits, but not extensive to date, and some pretty significant, or at least non-trivial costs, areas of concern around competition and innovation. And, to some extent, doing this exercise is kind of a useful exercise for me, because at the time that the DMCA was being considered, I had significant concerns and doubts about the DMCA, and nothing that's happened in the last several years has led me to change that view. So where does this lead us? Ideally, I think it would lead to some reforms in the way that DMCA is structured. And so here, this leads to my response to Gwen's great comments and suggestions about ways of implementing the kind of obligations under these treaties in other sort of countries. From my perspective, they're interesting because they suggest possibilities of reform to our own DMCA. Now, it's probably unrealistic to expect any kind of reform to go through, but at least they highlight maybe ways in which, if we wanted to keep the DMCA and try to eliminate some of these costs while preserving whatever benefits the DMCA serves, we might want to do that. So I do very much appreciate that, and I think this idea of learning from the U.S. experience is an important thing, because I think the DMCA was drafted rather prematurely, right, without any good idea of the types of technologies that it was intended to regulate. If you read the legislative history, there seems to be some confusion about exactly what the technology would look like. Some of the provisions of the DMCA kind of reflect this kind of confusion, and I think there is a lack of flexibility in the law, too, that's kind of problematic. And so ideally, the idea would be that we would learn from this. And so for a lot of these proposals, I think they would make a lot of sense, right? Kind of broader and more extensive exemptions for reverse engineering and interoperability and for encryption research. I agree that those exemptions tend to be very narrowly worded right now. They don't give enough free room as much as we would like. Also greater flexibility given to the Copyright Office to create exemptions. I think the way the exemptions parts of the DMCA are phrased have the effect of limiting what the Copyright Office can do, and the efficacy of that as a way of preserving some use rights for users and individuals. At the same time, though, I guess I do have some doubts about whether beyond these kinds of changes, really a more balanced version can effectively be struck. I really like the idea of creating more flexibility and privileges with respect to acts of circumvention, more room for fair use, but it's harder for me to see how we could create that kind of flexibility with respect to devices. Right? The question, I think, in my mind is, how do we permit the marketing of a device that only allows fair uses of encrypted DVDs? And I think that's a really tricky question, because to some extent I think the choice is between either permitting sort of unencrypting technologies or not. Right? There's kind of an all or nothing aspect of the technology, and maybe people are developing technologies that would allow a more fine-grained kind of thing. But I suspect the problem is not with the technology, but really with the U.S.'s conception of fair use. Right? Kind of the flexibility of it, the open-endedness of it, and maybe other countries that have sort of a different privilege, one that's a little bit more limited, might not have as much of a problem. But it's hard for me to see that, and so if the choice boils down to either a tools provision or not, it seems hard for me to think of a way of permitting this kind of flexibility without really gutting the tools provision. Now, personally, I would be fine with that. I think I would have no problems with that. But it's sort of hard to see how the copyright industries would at all agree with that, because it seems to be something that is if you think about the DMCA, I think it's really about the tools provision, right? It's not about the access provision, and all the cases are about the tools provision, and it's really about the technology, right? So it's hard for me to see kind of a more balanced version of that, but that would be great if we could construct one, and maybe the experiences of other countries will show a way, right? That they'll actually be more sensitive to this and learn from the U.S.'s experience and construct ways of doing this a lot more effectively. So in any event, that's sort of my quick read on where we are 10 years after the treaties, and I very much look forward to comments and questions.
Thank you. Our next panelist, Andres Guadamuz, is co-director of the AHRC Research Center for Studies in Intellectual Property and Technology Law. He holds both bachelor and licenciado degrees from the University of Costa Rica, as well as an LLM in International Business Law from the University of Hull and an MPhil from Queen's University Belfast. He's the author of numerous articles on intellectual property law and has consulted for WIPO.
Do we have the slide?
Yeah.
Okay. Thank you very much first to Jackie for the invitation. I'm very, very grateful to Case for the opportunity to be here. And I always start my presentations with an apology. And I think Ruth heard the joke, so I'm not going to say it again, of why this is the case. But my apology is that I was supposed to be talking more about the implementation of the agreements, and looking at the makeup of the excellent makeup of the panel, I decided to sort of look at the future implementation of where do we go from here, more of a case of looking at the future. And of course, to look at the future, we generally have to look at the past. So I wanted to give an idea of my personal involvement in the technological protection measures debate, mostly because I must admit I am a latecomer to this debate. Other than my involvement tended to be more sending snarky emails to mailing lists, begging people not to use the term DRM, to please use the term technological protection measure, because that's the one in the legislation, that's the one in the treaties, and because DRM really, when we're talking about that, it involves things that are completely innocuous and unexciting as metadata and digital expression of rights in language, for example. So it's not something that really you would go with a placard to the street to protest against. However, there was a turning point for me in the TPM debate, and it was when I purchased Coldplay's X and Y album. It's pictured there. I did not read the small print. When I'm buying a CD, I generally don't read the small print. And I realized, to my disgust, that it was protected with the technological protection measure. Why was I disgusted by that? Because I don't own a CD player. I listen to my music with a computer, and this came with a protection measure that wanted to install software in my computer that would not allow me to make copies, supposedly, of the CD. I cannot even begin to tell you how angry that made me. I got so angry that I am probably going to be admitting to some infringement here, so please, it's probably not a very good idea because this is being webcast, but the first thing I did was went on the internet, looked at the implementation, looked at the technology, broke it because it was extremely easy to do, and let's just say that I got involved in free sharing of the CD for a little while. Why? Because I just felt that there was something that I felt it was completely and absolutely wrong about this, because I wanted to play the CD without any problems in my computer. Well, yes, this is a very selfish feeling. But also the other thing that was a turning point for me was purchasing my iPod. And I started realizing that in order to copy all of my music collection, we don't have private copying or fair use in the UK. I was going to be involved in infringement of copying my CDs into my iPod. No TPN involved there, but I started me thinking. I started thinking about this, and at a personal level, was I doing something inherently wrong that we have legislation against it? So that pretty much started me thinking on this. And going back to the past, what is the reason? What was the technological reason that we have this legislation? Well, if we think of the technology that existed 10 years ago that we are protecting, it was something like this, CSS protection on DVDs, things like public-private keys protecting some works, dongles. I love this. It was software that you could only run with a dongle connected to the back of the computer. I think AutoCAD was famous. It's a dongle pictured here. And things like, there was talk about this defunct SDMI, I think it is a Secure Digital Music initiative, which did not get off the ground, but it was mostly that type of protection that we were talking about. And that is the technology behind the policy that we have at the moment. These prompted mostly look at the technology that even the proponents, even the people who were making the policy, were looking at some form of balance to build in. This is from the National Information Infrastructure white paper. I'll just read the part of that I think it's important. Such security measures must be carefully designed and implemented to ensure that they not only effectively protect the owner's interest in the works, but also do not unduly burden use of the work by consumers or compromise their privacy. That was some of the stated policies early on. Then even the creators, this is from a report in 1999 on strategies for implementation of the WCT at WIPO, a report from Marks and Turnbull. One of them was actually counsel for Time Warner. Copy protection technology must be implemented so as not to interfere with the legitimate distribution and communication of works to the public. So, depending on whether we think that the public interest was being served by this legislation, the initial idea was that there had to be some balance, and we are coming back to this word, balance, all the time. However, what has happened since is that the technologies that are coming through are pervasive and sometimes even dangerous for privacy. Typical case is that of Sony BMG, the rootkit. It was a PR disaster for Sony. It was technology that was transparent. The user did not know that there was this rootkit being installed into their computer that actually generated very strong security problems, and it left the system potentially vulnerable to hacker attacks. This is technology, technological protection measures that are dangerous, are not what we were sold when the WCT came into being. Things like hardware, built-in hardware protection, chips in players. My DVD player in my computer, for example, has a chip. It has a hardware protection that does not allow me to play DVDs in Linux. Well, I have Windows and Linux, which makes me, it doesn't really affect me that much personally, because then that means I have to boot into Windows to watch my DVDs. But even with software protection, I cannot break it. I have to, my legitimate rights, I would say, are restricted by the technology. Then there is something in the horizon, the Windows Vista Output Protection Manager, which is a nasty piece of technological protection measure implementation, which is going to allow the operating system not to play your media if it suspects that there is something wrong. It may play some very low quality version of it, but high definition or DVI outputs are going to be restricted, and this is going to be built in the operating system. What this brings me to is that we have all of this nasty technology that are not the technologies that we were sold. So one may argue that TPMs have been a failure. Some people may argue because piracy is pretty much the same as it was before. People who are technologically savvy to be able to break protection are going to break it very easily. The prevalence of things like BitTorrent, Pirate Bay, all sorts of media copying technologies are still out there. Granted, the WCT, I've seen some expression from policymakers that it wasn't really designed to completely curb all sorts of piracy, but to keep honest people honest or help them stay honest. However, some TPM has been extremely successful. I mean, iTunes is selling quite a lot of music. It's, depending on who you listen to, they could be selling more. But this is unobtrusive technology that people and users appear to be okay with. You know, they are buying and they are generally happy with it. But the problem with all of this and all these technologies is that is a problem of interoperability, of course. Some of the technologies are incompatible with one another. The iTunes, Apple's FairPlay TPM is incompatible with Microsoft's WMA, and it's also incompatible with AHRC. Even more interesting than that is that Zune, the new player by Microsoft, the TPM is incompatible with its own previous TPM, with WMA. So if you have music that you purchased in one of those stores, Napster, Yahoo Music, MSN, that use the WMA TPM, they won't be able to play with a new TPM that is going to be implemented in Zune. And Zune is, I just put it up here because it's sort of outside and it's not in the market yet. Then I am going to argue that the pendulum, I'm sorry for the crass use of the cliche, but the pendulum is swinging, I guess. There is enough public interest out there to warrant a look back or look again at these technologies and the policies. Particularly, for example, we have the famous John Johansson, DVD John. Is one of the most famous reverse engineering engineers. He helped break the protection on CSS for DVDs. He was not the one to crack it. It was cracked by a group of German hackers, but he was pretty much the person that was at the forefront of the legal action against it. Strange, this is him at the top, pimply teenager, and that's him now. He moved to California and has started a company. And he started a company that is reverse engineering Apple's FairPlay. Has been cracked. He cracked it and is now able to license it, apparently with the permission of Apple. So things are moving ahead. Another, well, in a sense, yeah. Then there is the French legislation. Professor Strowel is going to talk more about this, so I will just mention it. And I actually, the interoperability text that I have here is actually, I don't think it is the final version. But it's to give you an idea that there are legislators at the moment that are thinking about this and are drafting things like this. Technological protection measures must not result in the prevention of the effective application of interoperability. The providers of technological protection measures must disclose the information essential to interoperability. So there are legislators that are thinking about this. But also, there is a new way of thinking about this in licensing. Perhaps I'll paraphrase from the phrase of the solution of the machine is in the machine. Maybe the solution to the license is in the license. Things like Creative Commons anti-TPM provisions. This is the text on the new draft that is under discussion. When you distribute or publicly perform work, you may not impose any effective technological measures on the work that restrict the ability of a recipient of the work from you to exercise the rights granted under the license. Then we have the similar way of protecting works on the version 3 of the GNU General Public License, which is for software. It has this prohibition: no covered work constitutes part of an effective technological protection measure. Licenses are now being drafted that have an anti-TPM clause on it. And I'm trying to find a way of thinking about this. Is it copyleft TPM? I don't know, maybe someone can come up with a nice title of it. To conclude, because I see the stop sign, I think that there is something to be said for legislatures, but also for drafters of license, of open licenses, to include some form of anti-TPM provisions. I think that that is a way of swinging the balance again in favor of the public interest. Thank you.
Great. Well, our fourth and final speaker is Alain Strowel. He's a Belgian attorney who works in the Brussels office of Covington and Burling. He's also a professor at the Universities of Brussels and Liege. Professor Strowel is an active member of various IP associations, including the Licensing Executive Society, ALAI, European Patent Lawyers Association, Computer Law Association, and he's on the editorial board of many specialized law journals.
Thank you. And thank you for Jacqueline for the invitation. For me, it's a discovery of Cleveland, so I still have to spend some time in the city. But first of all, I have to do my duty to speak about TPMs, and I will try to present a European view. I will present a framework and tackle some unresolved issues. I think we might distinguish a few TPM-related issues that have arisen in the US and in Europe. Some are common, some are peculiar to Europe. I think the lockup issue that was already discussed is, of course, a common issue. And I think it's linked with a general and more theoretical copyright issue, which is whether there is in copyright such thing as an access right. And on that issue, we could talk a lot. I think there has always been some form of control of access within copyright, so it's nothing really new. But of course, the type of access control that copyright grants has been evolving over the years, and the question is whether the new form of access control is balanced or not. But I don't think there is certainly something like a copyright which is a new access right. But that's another issue. I will mainly focus on the two EU unresolved issues that are mentioned here, which is the relation between DRMs and copyright levies. That's something that we have in Europe that you don't have here. God bless you, because it's not an easy one. And there is a very interesting background question, is whether copyright will move towards a pure remuneration right without remaining an exclusive right. And there is some high pressure in that direction in Europe, so against keeping copyright as an exclusive right, but towards a form of remuneration through a levy system. I'll say more on that. And then there is the interoperability issue that popped up recently, especially in France, but in other countries. And there, I think the broad issues behind this new legislation is whether we will have some form of compulsory licensing scheme, at least for DRM technology, if not broader. And that's a discussion I will conduct at the end of my presentation. So first of all, and that will be some kind of introduction to the EU DRM protection framework. I can be quick because Gwen has already presented the main pillars of DRM protection in the US and as well in Europe, because we have the same. I will spend some time on the case law, on the relationship between DRM protection and private copying, because in continental Europe you have a private copying exception, of course. Then you suddenly have the question of how to reconcile this exception with DRM. Then DRM levies and the interrupt issue that I will tackle through one case law, that's the competition case law, and as well the recent French DRM law. On the 2001 InfoSoc directive, which defines the European framework for the protection of, let's say, TPM or DRM, I think we can use both terms interchangeably. So we have, as in the US, the prohibition of the acts of circumvention if the knowledge requirement is met, and as well the prohibition of what Gwen has mentioned, the tools or the so-called preparatory acts like the manufacturing of circumventing devices. And we have the same primary purpose. It's only when the device has as a primary purpose to circumvent TPM protection that it can be prohibited. We have as well a definition of what TPMs are, and more particularly what effective TPMs are. And of course, like in the US, not only copy systems, but access systems are covered by the definition. And then there is, and that's different. That's why I will spend more time on that. Article 6.4 of the so-called InfoSoc directive provides for a mechanism, an enabling mechanism, whose objective is to ensure that beneficiaries of some exceptions can, in practice, really benefit from those exceptions. So the big issue, of course, and that was already stressed this morning, is how to find the right balance, especially in that field. And we have to take into account that there are three levels of protection: copyright protection, and then a technical protection, and the legal protection of TPMs. There are two issues. First of all, an issue at the level of the technical protection, and then there is the problem of having at the level of the legal protection of TPMs, a mechanism to ensure that the exceptions to the first level, copyright protection, are protected there despite the protection of TPMs. In the InfoSoc directive, the two different issues are differently tackled. For the protection of TPM second level, you have some exceptions in the DMCA, the 7, I think, exceptions. In Europe, they are not in the directive, and they are not in the implementing laws as well. But there is some reference to those exceptions, at least to some of them, in the recitals of the directive, like the exception for the research in cryptography, or the decompilation exception in recital 50. But the member states have not implemented those exceptions. There is no requirement to implement the recitals of a directive, only the provision of the directive. But they are there, nevertheless, allowing some form of research and allowing decompilations, because in Europe we have a very detailed provision in the 1991 software directive, which defines when reverse engineering can be conducted. What we have in the InfoSoc directive and as well in the implementing laws is a mechanism in Article 6.4 already mentioned to ensure that the copyright exceptions are in practice respected. And the first best solution proposed by the directive is voluntary measures. So copyright owners should, for instance, by making hard copies available or by other means, ensure that the beneficiaries of some exceptions can benefit from them. That's the first best. But of course, it's not clear, it's not ensured that they will do that, so there is a second best solution, which allows member states to intervene in order to promote those measures. And the member states have to intervene in certain cases. they have to intervene to ensure the benefit of 7 exceptions. I won't go through them. Some of them are really hardcore exceptions, public policy exceptions, but there is a lot to say about this list. It's not very coherent, it's not exhaustive about public policy exceptions, but at least that's an obligation. How they implement this obligation, that's left for them. I mean, they can allow for some form of class action, some rulemaking, some mediation. That's dealt at national level. Concerning the private copy exception, which is, I think, a different type of exception, at least it's more focused on consumptive use, not like some of the hardcore public policy exceptions mentioned. Here, member states have no obligation, but they are allowed to adopt measures to ensure the benefit of the private copying exception, with a very important carve-out that concerns on-demand services. In that case, because contracts can be concluded, member states cannot introduce measures to ensure that the private copying exceptions are respected. So that's the framework. What do we have in the case law? Well, in fact, we don't have case law on the exceptions of copyright and the protection of TPMs. We have a few cases that I will quickly present now, but that do not already deal with the issue of the protection of TPMs. The issue in those cases is whether, because consumers have a private copying exception, can they oppose to use of TPMs? Can they exerce an affirmative right that the producers of the media delete or remove those protections? And that was the issue, for instance, in the French and the Belgian cases that were introduced by some consumer groups. The French case went till the Cour de Cassation, so the Supreme Court. That is the so-called Mulholland Drive case, because it involved the TPM protection on the DVD of the well-known movie. What did the Supreme Court say? Well, it uses, in fact, the criterion of the 3-step test already mentioned by Professor Wever this morning, which is in Article 13 of TRIPS. So the private copying exception, according to this court, does not allow to oppose DRM implementation if private copies would conflict with the normal exploitation of the work. And the case now is sent back before the judges of second instance, which will have to decide what the normal exploitation of DVD means, and whether there might be some problem for the producers if the DVD protection is removed. So they will have to conduct some form of economic analysis of what the normal exploitation of the work means. There might be criticism about this approach. I think it's correct because that's the law. But of course, if you adopt this approach, there is no real room to take into account the interest of consumers. That's not in the test. By the way, I think there are better tests in TRIPS for design and for patents. The 3-step test says that it should take into account the right of third parties, which is not in Article 13 of TRIPS concerning the copyright 3-step test. In Germany, the case was slightly different because it's the person who bought a medium who claimed that his enjoyment of property was affected by the presence of some copying protection. That claim was rejected by the Federal Constitutional Court. And in Belgium, it's not clear whether the Court of Appeal rejected the existence of an affirmative right to private copying. I think it was more on the basis of a problem of standing that the consumer organization could not win the case. Okay, now let's move to the first unresolved issue, the interface between technical measures and levies. And the question we have in Europe is the following. How should levies, which according to the directive grant some form of fair compensation to the authors, take into account DRMs, which could be considered as offering a full compensation, because then you decide whatever you want. And the problem is that whether you can combine both systems, you can say that in principle you should not, as a copyright owner, have the euros coming from the full compensation and the small cents coming from the levy system. And that's very difficult to organize. The main provision, you have it here in front of you, is Article 5.2b of the InfoSoc directive, which allows member states to introduce a levy of a fair compensation system, but it should take into account the application or non-application of technological measures. So, in fact, in principle, you could not have a full combination of both systems, more levies and more DRM. But in practice, what happens in Europe is that there is an increase in levies and probably an increase in the use of DRMs. So that's a big issue. In principle, Article 5.2b of the InfoSoc directive would impose some kind of phasing out of levies. If you have more DRMs, then you cannot rely on the lump sum system that is the levy system. Levy system is some form of, I mean, you can call it a tax on the medium, on the machines, and the money is collected and redistributed to the right owners. Other issue, the interop issue. There, the issue is how to ensure full enjoyment of the content that the consumer has acquired without chilling technological innovation. The recital 54 of the directive promotes interoperability, but we have now in law, in France, some law. I think that, unfortunately, I cannot speak anymore because time has run out. I would have liked to speak about the Virgin Mega versus Apple case, which concerned already at the level of the courts and the competition authority in France, that issue, and about the 2006 DRM law in France, which brings a lot of new issues. But maybe I'll keep it for the discussion. A conclusion. That's, I suppose, the lot. Thank you. There are two broader questions, I think, behind this whole topic, and that's standard. Is copyright getting too strong? Is copyright more threatened than ever? I would call them the two nightmares of the right holders or of the consumers. I think that it's a difficult issue. Which perspective is accurate? In one sense, it's clear copyright is getting too strong, favoring large, powerful companies. In another sense, copyright is more threatened than ever because of some advances in technologies. And we could list and we could discuss them, of course, all the signs that establish that copyright is getting too strong, and protection of DRMs might be one. But there are many other developments going in that sense. At the same time, it's possible to sustain that copyright is falling behind. Maybe, for instance, because DRMs get hacked easily, and as well because of the other issues that I mentioned here. So, which perspective is accurate? Well, I won't answer that question. I'll leave it to you. Thank you.
Well, thank you to all of our speakers for a very interesting panel. We have a few minutes for question and answer now. Yes, and please wait for the mic, as always.
Yes, this is a question to the U.S. participants, and it concerns this diabolical use of the DMCA to control aftermarkets, like in the Lexmark and the Chamberlain case. Most people, reasonable people would agree that this really wasn't the intent of Congress. On the other hand, when you read those two cases, particularly the Lexmark case, you're left with a lot of ambiguity about what the rationale of the rule is, and you have both spoken for some sort of revision of the DMCA in various ways, or complete abolition maybe, but certainly revision. So the question is twofold. Do you have a doctrinal fix that the courts can use to construct a relatively bright line rule to give us some sort of future direction? And secondly, if you don't, do you see a legislative fix? How would you articulate, or how would you encapsulate a legislative fix?
Yeah.
I don't have a doctrinal response. I don't think there is one. Perhaps, unless I'm misreading Joe's comments, I think I have a different take on how I grouped them as 4 cases. 3 of those 4 cases, and Lexmark in particular, ended up being resolved at the appellate level in favour of the aftermarket party, for want of a shorthand way to describe that. But I don't feel that the Sixth Circuit decision in the Lexmark case gave any clear idea. Essentially, what the court said was, you didn't have an effective technological measure because you didn't have strong enough copyrighted work. My concern with that case, and with all of those cases, is that if you had a smart enough copyright owner, all they have to do is change their practices, just tweak their practices a little, build a stronger, more build a toner program that actually meets the originality test, and you have technological protection measure legal protection. So I don't think there is a nice clear-cut rationale that gives me any comfort that those cases won't repeat. That's exactly my concern with the scope of the US provisions. In terms of the US domestic agenda, I think that the right response is a legislative fix. I think that HR 1201, Representative Boucher's bill, that would allow for a circumvention and use of tools for circumventing for non-infringing purposes, is the way to fix that. My comments about principles were trying to outline the scope of what you could do if you were in another country. Ideally, I'd love for the DMCA to be reformed here, but I appreciate that we have a particular set of circumstances that make that hard. The one point I just want to also add is, in terms of tools regulation, I wanted to flag that I didn't actually apparently I didn't read out my 3rd point, and on my last set of recommendation slides. And I just want to put this out there for the purposes of documenting the full range of policy options that are out there. There is another approach rather than a black and white ban on tools, and that is having something like the Australian approach. The current Australian law has this process in Section 116A where you can petition for import and use of a circumvention tool for a specified non-infringing purpose. So there's a range of policy options out there. In the US context, I think the right response is legislative, and it's Representative Boucher's bill, a clear-cut right of circumvention, so that consumers know when they've got the right to circumvent. Thanks very much.
So I'll just respond. I actually find those 2 cases, the Lexmark and the Skylink cases, doctrinally kind of problematic. Like, I kind of have a hard time seeing where the courts get their results. I remember being somewhat surprised with the results on appeal. And I think they do raise all sorts of troubling questions, especially the Skylink opinion, which kind of creates this almost a rule of reason kind of approach to DMCA liability, right? And so I read those cases as being intensely policy-driven, right, or at least recognizing that this is, as a matter of congressional intent, clearly outside the scope of what they intended, and then sort of finding some way to force that result into the doctrine. And so from a policy perspective, I'm perfectly happy with those cases, at least in their results, but I have a hard time seeing how they doctrinally got there. I think I'd have a preference maybe for, exactly the same thing, either a legislative solution or some kind of expanded rulemaking proceeding where the Copyright Office could exempt, categories in this way more expressly.
I had exactly the same response as Joe to those, which is I have more confidence than Gwen because I think they're so doctrinally problematic that you have to believe courts are just going to work out some way, depending, and they can keep finding ways when you bring really stupid cases before them. And so I have the same response as Joe, but I wonder whether, I think I mentioned this to Joe before, but I'll put it to the whole panel, is, you know, in the UK, and this picks up on something Ruth said this morning about copyright going to protect products in some way, sort of, you know, rather than what we think of as creativity in the old world. There's a case in the 80s in Britain, British Leyland versus Armstrong Patents, which is about the exhaust pipe of a car, in which essentially the court applied a property law rule that says you cannot derogate from the grant of the bit of property that you sold to someone by enforcing your intellectual property rights in ways that prevent them being able to do what they need to do with the bit of property, which in that case was repair the car. Is that type of doctrine something that more generally applicable you'd find useful in the DRM context? And in particular, would that then, if you applied that doctrine, could that actually tie the doctrine to the contours of copyright and those values? So that's my question, really, which I'll give you a second while you're thinking about it, Gwen and Joe, and I'll throw one other one in, which is to Alain, which is on the Article 6.4 on the exceptions rather than the private copying, on the exceptions where the states are mandated to ensure the availability of the exceptions. Where do you get that the supply of a hard copy is enough to say that the states or the right holders have made available to beneficiaries the benefit of the exemption? I wonder if there's somewhere, because I hadn't seen that. So.
Yeah, I can chime in. So this idea of, I think, bundled in this in that sort of example of the exhaust pipe, right, are a whole bunch of doctrinal categories like exhaustion or the first sale doctrine, right, in copyright, or in real property, right, this kind of idea of restraints on alienation and all the rest, right, at least here in the U.S. And there is something, in my mind, kind of attractive about those doctrines as maybe a way of kind of limiting the reach of copyright owners. I think the difficulty I have is finding how doctrinally to implement any of those, because they seem so contradicted by the DMCA, right, in the sense that you have a federal enactment that effectively, by its very terms, kind of wipes out all of that, right? And I guess the other doctrinal hook would be misuse, right? Dan Burke has suggested that there could be an anti-circumvention misuse kind of doctrine. But to some extent, in order to bring a misuse claim, you have to be clearly outside the scope of the DMCA to begin with. And that seems to be the entire issue, right? That in a lot of these cases, that's the question, right? Are we within the scope or not? But there is something attractive to me about that idea of maybe importing it in our consideration of the proper scope of the DMCA or in other ways like that. Yeah.
1201C, although it was argued in Corley, I thought Kaplan and others gave it short shrift. All right, you have a section in there that says this is not intended in any way remotely to affect fair use. And it seems to me if you want a hook somewhere in the statute, it's not hard to find. It doesn't get you all of the copyright contours, but it gets a chunk of them.
That's a good point, actually. And that section, you're right, has been kind of interpreted narrowly, right, by those cases. But certainly, you could at least point to a specific section now, as opposed to maybe in Skylink and Lexmark, where there isn't that kind of a hook. No, I think that's right. Yeah, that's a nice point.
I mean, I really think that in the US, the question is whether you might be able to look at some sort of misuse type framework. The problem with my understanding of basically is that that's foreclosed because of the legislative intent, the clear statement about the scope of the protections here. So copyright misuse, if the DMCA were limited to the scope of copyright, then I think you would actually have the ability to bring a copyright misuse claim. So just to, I guess, to elaborate on Joe's point, this is one of the things Dan Burke and Julie Cohen have raised. There's sort of a catch-22 here, and that's one of the reasons why one of my recommendations is we look at something like an administrative process that looks at the anti-competitive impacts, and it needs to be low barrier and it needs to be consumer-friendly. So I would advocate for something like a modified version of the UK implementation of Article 6.4, some sort of low barrier administrative proceeding that could actually take into account potential anti-competitive impacts, because I'm not sure that we just because of the way that things have been set up in the United States, I'm not sure that we have the ability to use the existing copyright misuse doctrine. And obviously for other countries that don't have that there won't even be that safety net, even if the scope of protection were limited to copyright.
Yeah, I can be very quick. That's not into law. That was, I mean, a possible reading that I was suggesting.
Okay, do we have time to take one more quick question, maybe? Is there one more question?
The rock, paper, scissors. No, I was just going to comment, Joe, I really appreciate the cost-benefit analysis approach to evaluating these laws, right? And as you mentioned, it depends on where you sit, right? I might have a different assessment of what the costs are and what the benefits are, but that kind of analysis is exactly what we should be doing. And Andres, when I think about the iPod, I think to myself, you know, I'm not sure they needed the DMCA to have the iPod and all the technological protection measures that go along with it. So is that a success of the DMCA? I don't think so. It's a success of their marketing ability and their ability to finally get the music industry to play along. So it's that cost-benefit analysis that I think is a really helpful tool to use.
I guess just a quick comment. You're absolutely right, and one of the reasons why the iPod and iTunes particularly has the TPM is because it's easier for them to get agreements from the music industry that they won't have, and it's really for that reason, because it is actually very easy to get around the technology. You just burn the song into a CD and then rip it again. Am I giving instructions on how to? But yeah, the success has been despite the TPM, not because of it.
Can I chime in with an alternative point of view on that? Okay. I think the fact that the DRM on Apple iTunes is so easy to break actually argues the other way. I think that the DRM is there so that Apple can basically gain control of the marketplace for MP3s. And kudos to Apple for working it out. Like, I've got an iPod. I love my iPod, but it's precisely because the DMCA gives rights owners and technology companies the ability to use technological protection measures as a hook for basically controlling the marketplace and devices. That's precisely, I think, the reason why many of the proponents of the DMCA actually sought legal protection. I think that's clear from Marks and Turnbull's 1999 paper that you mentioned before. It's basically set out there in Appendix C. That's how we're going to actually build in region control into DVD players. So I think it's entirely intentional, but whether that's a good thing from a policy point of view is another question.
Yeah, maybe on the French law, I think it's interesting to see how the law is shaped by some interest. And I think it's quite clear in France that the DRM interoperability provision is essentially a tool for the content, the music industry, to negotiate better deals with Apple. That's one of the issues I wanted to stress, but when you look at the conditions, it's quite clear. So there are some strange things sometimes in legislation.
Great. Well, thank you all very much. We have a short break before the final panel of the day.